Otieno Gola writes and said he wants the Form 32A for all 229 stations. Joaquim Bosch and company write and say they want for 238 stations. I believe the petitioners, first petitioners, have asked for 517 stations. Obviously, with the time we have, and you've already spent the whole day haggling on this, 24 hours or 48 hours are gone, it is now impossible to comply with that order, and therefore, the court directs as follows. The applicants shall only, the IBC shall only provide the 32As and 34As Book 2 from 41 stations, polling stations, that are in the affidavit of Celestine Anyango Opio. That is the only way that exercise can be can have meaning. And that those forms will be a sample for which you can submit in accordance with your pleadings. We cannot allow you, we said, to go outside your pleadings, because what's happening now, we are creating a new case out of these forms. So please stick to your pleadings, and once we get those, the report on those forms, you submit on them in the context of your pleadings. And so, Caleb Khalifa's petition, Willis Otieno's petition, that Willis Otieno, the petition by Raila Odinga, and the petition by Joaquim Bosch. Those are the three petitions where these issues arise. Please submit only on those issues. I hope I'm clear. And we don't expect debate on this, we expect compliance. I thank you very much, CJ. I thank you, Council. And remember, CJ, and Council, this exercise must be conducted before 2 p.m. tomorrow. What will be undone by tomorrow will be undone. I thank you.
Thank you, Justice Renaura.
My Lady the Chief Justice and members of the court, we are also having difficulties with the orders relating to inspection of the servers. We have been given restricted access only to the result transmission system, and only it has not been granted yet, only to one server, and it is established that the IBC has got 8 servers. We have taken the decision to write formally to the registrar in the hope that the court eventually can resolve this matter as quickly as possible, because we are running out of time. But there's no compliance in terms of the orders that the court gave.
We are aware about that issue. We are following up on the question, and as far as we know, the exercise is continuing. Should there be an issue later in the day or tomorrow morning, we shall receive a report. But as far as we know, by the time we got out of here, the exercise had commenced. There was an agreement on how to access the server that was given, and the issue of cloning is being addressed. So let's leave it for now. Let's report again tomorrow morning. I thank you, CJ. I thank you, Mr. Orengo. We are aware about that issue.
May I, with your very kind permission, Madam Chief Justice, I would like to rectify a mistake. We intimated to you yesterday that the 2 commissioners, Professor Guleye and Boya Molu, would have separate representation. That has been achieved, and we have Dr. Willie Mutumbwa, who is in court, and we have for Mr. Professor Guleye and Mr. Peter Wanyama for Commissioner Molu. Thank you.
Okay. That is noted. We can now proceed to invite counsel for petitioner in petition number E002 of 2022.
Thank you very much, Your Ladyship, the Chief Justice, members of the court. I wish to make submissions this afternoon before you on behalf of the third petitioners in the consolidated petition. The petition filed by the third petitioner, initially as petition number 2 of 2022, raises or has issues that deal with all the issues that had been framed all 9 issues that had been framed for determination by the court. But in respect of issues number 1, 2, 3, 4, 5, and 6, I will rely on the written submissions that we have filed or that have been filed on behalf of the third petitioner. And I will utilize my time on my feet this afternoon to focus on issue number 6, the cojoined issue number 7, number 8, and number 9 of the issues that the court framed or the court has framed for determination. I wish to get straight into issue number 6. And my humble understanding of issue number 6, and I will read it just for clarity, whether the IEBC has carried out the verification, tallying, and declaration of results in accordance with Article 138(3)(c) and 138(10) of the Constitution. Again, it is my humble understanding from members of the court, because it states clearly what the other commissioners or the roles that the chairman had designated the other commissioners to do. At page 41, there is an internal memo or a letter signed by the chairman on the 22nd of July, addressed to the vice chairperson Juliana Cherere and Commissioner Boya Molu. And it is headed Appointment to the Media and Call Center Management Team for the Presidential Tallying Center, Bomas of Kenya. And he goes on, he says, consequently, you are hereby appointed to the Media and Incident Reporting Team of the Presidential Election Tallying Center as follows. Juliana Cherere, Team Leader. Commissioner Boya Molu, Alternate Team Leader. And their roles are set out there. Terms of reference of your appointment: provide liaison between the Presidential Returning Officer, who is himself, and the National Communication Center, preparing periodic briefs for the Presidential Returning Officer to address the media, briefing the Presidential Returning Officer on electoral activities across the country. Nothing to do with tallying and verification. The two subjects of that letter are commissioners of the IBC. The next letter is on page 42, also dated the 22nd of July. This one is addressed to Commissioner Francis Wanderi and Commissioner Irene Masit. Again, under the hand of the chairman, and it is appointment to the Logistics, Welfare and Security Team at the Presidential Tally Center, Bomas of Kenya. Again, he appoints them in the second paragraph. Consequently, you are hereby appointed to oversight, provide policy direction and strategy formulation for the Welfare and Security Team of the Presidential Election Tallying Center. He then states their names and he states their terms of reference as security of the Tally Center and installations, the Tallying Center's logistics, planning and organization, security of members of the commission, staff, VIPs and other visitors, transport for commission staff, any other duties assigned. Important, those are two commissioners. None of them has been assigned to tally and verify. The third letter is on page 43, and this one is addressed to Commissioner Justus Nyang'aya. Again, Justus Nyang'aya is appointed to be in charge of dignitaries and protocol. And in the second paragraph, he is told that as team leader for dignitaries and protocol, he will be responsible for providing support services to the commission, managing protocol of dignitaries and VIPs, managing access to the Presidential Tally Center for accreditation, for accredited media, observers and agents, and any other responsibility. Now, those are out of 6 commissioners. Those are 5 commissioners. None of them is assigned to tallying and verification. There is a last letter, also dated the 22nd of July on page 44. This one is addressed to Commissioner Professor Abdi Gulie and Mr. Marjan Hussein Marjan. I wish to point out to this court and ask the court to note that Marjan Hussein Marjan is not a commissioner, but he is merely the CEO of the IBC. Now, these two are appointed to the results management team at the Presidential Tally Center. Their duties are undertaking quality assurance of result forms received from the Presidential Returning Office desk, tallying and processing of election results. I urge that that is the language of Article 183.3, and assisting the Presidential Returning Officer in managing a record of the election results. Tallying and verification, I submit, on the admission of the chairman of the IEBC, was done by Professor Abdi Gulie and Marjan Hussein Marjan, and not by the IEBC. The tallying process continues unconstitutionally as it was being conducted, and I want to pose the question and attempt an answer to the question: how does that process then end? That process ends as set out in paragraphs, again the same affidavit of the chairman, at paragraph 76 onwards. But the story that he tells, or the deposition that he makes, starts in paragraph 66. And I will read it because it is important. he deposed. Shortly after 2 p.m., the commissioners and I had a meeting to be briefed on the final results by the commission secretary, stroke CEO, an alternate leader of the Tally Center. The meeting was only for a briefing. He then goes on to say, the briefing was to be done before my declaration in accordance with Article 138(10) of the Constitution. So according to the chairman, all that was going to take place between him and the commissioners was a briefing, and he then goes on and declares the results. What did he do? After he narrates the story of the visit between paragraph 67 and 75, he then goes on under the substantive heading, Commission Briefing of Final Results. After the NSAC team had left, the Commission Secretary and Chief Executive Officer, who was also the alternate leader of the team of the Tallying Center, Mr. Marjan Hussein Manjan, walked into the boardroom. The purpose of the meeting was to receive the final tally of results of the presidential election before I could proceed to declare. From the chairman's own evidence, he assembles a team that comprises Professor Gulie and Mr. Marjan. They tally and verify the result, and Mr. Marjan is merely coming to brief the commission. What happens after that? There is between paragraph 77, where he states that copies of the results were handed to the commissioners, and that is all that was done. The result had been tallied and verified elsewhere. The copies are merely handed. There is a conversation. There is no agreement. And of importance, at paragraph 81, the chairman deposed as follows. I walked out of the meeting room accompanied by Commissioner Professor Gulie, Commissioner Molu, and the Chief Executive Officer. And he then went to the auditorium and declared the results. In the chairman's own words, and I submit that his narrative of what took place is important. That is how the tallying and verification of the result in the presidential election took place. To answer or to attempt an answer to the question that is sought by this court by framing ground number 6 as it is, whether IBC carried out verification, tallying, and declaration of the results in accordance with Article 138(3)(c) and 138(10), I would answer that question in the negative. Tallying was carried out by the chairman alone. At best, the chairman, Professor Gulie, and Mr. Marjan. A quick look at Section 5(1) of the IEBC Act would disclose that those 3 gentlemen, however eminent, are not the IEBC. What the Constitution enables the chairman to do on his own is to declare the result. I submit that the election is a process, it is a progressive process, and the completion of one process enables another. If you do not complete voting, you cannot tally. If you don't complete tallying, you cannot declare. I submit that tallying and verification, having not taken place as provided by the Constitution, then there was no result for the chairman to declare. There is an attempted justification by the chairman for his decision to tally and verify the result on his own. That justification exists in an affidavit sworn by the chairman. This time it is drawn by the firm of Iseme Kamau and Maema Advocates. It is at page 14, at paragraph 62. The chairman attempts to justify his decision to tally and verify alone from this court's decision in Raila 2017. With tremendous respect to the chairman, the issue of his ability to tally and verify on his own was not an issue in Raila 2017. and with the clear provisions of the Constitution, in Article 138(3)(c), there can be no judicial foundation for the chairman's tallying and verification on his own. At the beginning of my submissions, I had submitted that I wish to demonstrate to this court that the chairman executed a very well calculated scheme to grab the election and to run the election on his own. And this is how, in my estimation, he did it. Elections are normally commenced by a notice of elections that is issued under Section 14 of the Elections Act. Regulation 12 of the Elections General Regulations then provide that certain specific notices will be issued for the presidential election. Regulation 12.2 provides as follows: immediately after the publication of a notice under Section 14, and the notice under Section 14 of the Act is published by the Commission, the returning officer of every constituency shall notify the holding of a presidential election in Form 8. Now that's important, because I had also said that earlier on that there is no such role as a presidential returning officer or national returning officer. And I say so because of the provisions of Article 138(2) of the Constitution. Article 138(2) of the Constitution says, if two or more candidates for president are nominated, an election shall be held in each constituency. An election shall be held in each constituency. A returning officer is defined in Section 2 of the Elections Act as a person who conducts an election. The chairman is merely enabled to declare. The conduct of the election by dint of Article 138(2) is by 290 returning officers. The notice that they were required to publish under Regulation 12(2) was never published. The 290 notices from the 290 returning officers was never published. There is no position like the national returning officer. So the first infraction is that there are no notices. The chairman constitutes himself as the national returning officer, and the notices are not published. The chairman gazetted himself. I believe the Gazette notice is the Gazette notice, I think it is the 22nd or 28th of May. He gazetted himself as the national returning officer. As a matter of good electoral practice, returning officers are gazetted with deputies. The chairman gazetted himself with no deputy. It was his election to run as he saw fit. There is the issue of the deployment or the unilateral transfer of returning officers. My learned colleagues who appear for the commissioners have dealt with that extensively in their affidavits, and I'm sure they will submit on it when they have their time on their feet. Again, the deployment of commissioners at Bomas was not accidental, it was deliberate, it is documented, and the details are spelled out, the duties are spelled out in detail. Again, the postponement of the elections is another issue, and I wish to pose this question at this juncture. We have interpreted constitutional time as being strict, but the chairman of the IEBC has on more than one occasion dealt with constitutional time as if it is elastic. The elections that he postponed on the 8th of August were not the first elections that he postponed. In the second week of March 2000, the then sitting MP for a constituency in Kwale called Msambweni passed away. The Constitution provided that that by-election be held within 90 days. That by-election was not held until the 20th of December 2000, or not 2000, 2020. Again, that is another election that was postponed, and it just went by. The manner in which the commission conducted itself, or the chairman conducted himself, around the commission dealing with these very petitions is also instructive in the manner in which the chairman had assumed certain roles and capacities to himself. I wish to refer to the affidavit of Juliana Cherere, filed in this court on the 26th of August. And I wish to refer members of the court to the to annexure JC12. That annexure is correspondence, it is internal memos within the commission. The first one is signed by the 4 commissioners, and it is a request for a special meeting whose agenda is to deliberate the commission's position in light of the presidential elections petition filed in court on the 22nd of August. That letter is dated the 24th of August, 2 days after the petition is filed. Annexure JC12 or JC13 is a follow-up to that letter. There is no response, or there is no response by the chairman to the initial memo, and there is a follow-up now asking for a meeting on Friday the 26th at 9 a.m. at the Commission's offices to discuss that purpose. Of tremendous importance is the letter, or is the internal memo exhibited as JC14. This is a response to the request for a meeting. This one is not under the hand of the chairman, but under the hand of the CEO, where he convenes that meeting for today, the 31st, the first day of hearing. Is that a chairman acting in the best interest of the commission? Is that a chairman acting constitutionally responsibly? The effect of the unconstitutionality in the election was dealt with by this court's decision in Joho 2014. Anything done under that unconstitutional piece of legislation is a nullity. The votes that were cast by the people of Kenya having not been properly tallied and verified, or verified and tallied, there can be no declaration. I wish to assert the submission made by my learned senior colleagues that an election is a sovereign process that belongs to all Kenyans. And via the Constitution, we have delegated the management of that sovereign process to the IEBC. It was a constitutional infraction of monumental proportions for the chairman to seize the election as he did. And for those reasons, it is my humble request that all the prayers that are sought in petition number 2 of 2022 be granted.
Thank you, Council. Next. Yes.
If may please, my lords and my ladies, I start by saying that election is a process. I'm Otieno Willis, appearing for petitioner number 4. Election is a process that ends upon the determination of the true wish of the voter. And when that process is unconstitutional, it is not enough to throw numbers that are arrived at through an unconstitutional way to assert that that is the true will of the voter. The first issue I wish to address, my lords and my ladies, is issue number 6. And issue number 6, caught to it, is Article 138(3)(c) of the Constitution, which vests upon the IEBC the duty to tally and verify results from all polling stations and to declare the result. I want the court to take note of the last part of Article 138(3)(c. The IEBC shall tally and verify the count and declare the result, not the results. Results is the numbers. Result, without an S, is the outcome. And I want the court to notice that 138(3)(c is a responsibility on the commission, not on the chairman. So the first declaration of the result of the verified and the tallied counts is made by IEBC as a commission. Then the chairperson, again, the word of the Constitution used is the chairperson in Article 138(10) shall now proceed to formally declare the results and issue the certificate. My lord and my ladies, Article 138(3) sets out a 4-tier process. Tier 1 is the polling station. Tier 2 is the constituency. Tier 3 is the National Tallying Center, in brackets IEBC Commission. And Tier 4 is the chairperson. Tier 2 cannot function without Tier 1. A constituency cannot function if polling fails at the polling station. A returning officer cannot go to a polling station and make a declaration of the results of that polling station. It's not his function. The IEBC as a commission cannot go to a constituency and fill Form 34B for a particular constituency. If they do so, they failed it. Similarly, the chairperson cannot move from Tier 4 and go to Tier 3 and purport to verify and tally the votes, the counts, and make a declaration. Each tier must perform its function. It is now tried that under Article 81, elections must be conducted by an independent body. The presidential elections whose results we are disputing were conducted by an independent individual, not a body. Because if it was a body, I would not have been served with documents from commissioners confirming they did not participate in the verification and tallying of the count. A majority of the commissioners, IEBC in their replying affidavits served upon me, has confirmed they did not tally and verify those results. My lords and my ladies, I wish to state, Chapter 15 of our Constitution establishes constitutional commissions and independent offices. Where the Constitution desired a function to be performed by an individual, it established an independent office. The Office of Auditor General, the Office of Controller of Budget. But where it desired a function to be performed by a commission, it established an independent commission. The Office of Election Management Body is a commission. It is not established as a chief elections officer as an independent office, as Wafula Chebukati seeks to run the commission. My lords, if the people of Kenya desired to have an individual, they would have simply reverted back to 1988 when we had a supervisor of elections. I will not go back into what has been submitted, but only to add on that point that where a commission has been properly constituted and the number is set as an odd number, the Constitution and the law presupposes there may be dissent, and the oddity of the number is to make sure that ultimately a decision will be arrived at. In this particular case, the oddity of the numbers led to a decision of the commission. And a majority of those commissioners have told us in their affidavits that they did not carry out a tally and verification of the results. Tier 3 failed. Confirmed. Let us go to the state of mind of Mr. Wafula Chebukati on the 15th when he was conducting this function. Just to confirm to you that he did it himself. In page 12 of volume 1 of my documents is a statement dated 17th of August by Wafula Chebukati, in which he says that it was his sole responsibility and that the commissioners had no role in that process. That was his state of mind. But the same person, when he comes to court in his replying affidavit, at paragraph 75, 76, 84, 85, he turns around and says, the commission in a collegiate manner arrived at a decision. Why is he lying? If on the 17th he has told us it was his sole responsibility. When he comes to court now, he says the verification was done by everybody. And it's important that I point out in the replying affidavit by William Ruto at paragraph 16 and 17, he also says that it is the sole responsibility of the chairperson to verify and to tally the results. That was their state of mind. But we are submitting it is not the law. The law is everybody must conduct it. These issues which we are raising were canvassed in the Maina Kiai case. Hele Khalifa, the petitioner number 1 in this petition, was a petitioner there. And the court said the IEBC, as opposed to its chairperson, upon receipt of prescribed forms containing tabulated results for the election of president, electronically transmitted to it from the near 40,000 polling stations, is required to tally and verify the results received. That was the law in Maina Kiai. And they go further to say the architecture of our laws is that the power to tally and verify cannot be vested in an individual. Supreme Court Raila Odinga 2017, the court said in paragraph 292, the failure by the first respondent to verify the results in consultation with the second respondent, IEBC and the chairman, failing to act together in concert, meant that it went against Article 138(3)(c). That was binding. To drive this point home, my lords and my ladies, taking into account those two decisions, the number of IEBC commissioners are 7 plus the chairperson. The number of Supreme Court judges are 7 plus the Chief Justice. If, as been...
Counsel,
yes.
Do I understand you to be comparing the Supreme Court, its architecture, and the IEBC?
No. I wanted to give an example.
Be careful, Counsel.
Okay, I'll try to be very careful. I'll try to be very careful and not extreme. I just use the number of 7. That in terms of 7, the Supreme Court sits as a full bench when constituted. And the rules on arriving at a decision is by majority. And there have been even instances when the Chief Justice of this court has been on a minority. And we never saw a Chief Justice walking out there saying, my minority decision is the decision of the Supreme Court of Kenya. In the instance petition, we have the chairman and Gulie and Mr. Molu walking out saying, our minority decision is the decision of the IEBC. How absurd can it be? And to buttress that point, Mr. Nyamodi has clarified what roles were given to the commissioners as opposed to tallying. The roles given, for example, to judges are known to adjudicate over matters. If it were to happen, and I know it can never happen, that the Chief Justice assigns judges some to go and receive advocates, some to go and receive VIPs, some to go and receive the media, then the Chief Justice remains with only 2 other judges, and they make a decision and tell the people of Kenya, this is the decision of the Supreme Court of Kenya. How absurd will it be? That is what transpired in this particular case. Commissioners were relegated outside their core functions, and the function performed by an individual, what I call a minority of the IEBC. That was never the intention of the law. On the technological aspect, as I move to summarize, I want to refer, my lords and my ladies, that's issue number one, on the qualitative test of the technology. IEBC, under the Elections General Technology Regulations, conducted an independent audit of the biometric voter register. This is what your auditors said at page 32, volume 1 of my bundle of documents. The KPMG report found that 481,711 persons were not qualified to be on the register, but they were on the register. Duplicates. One person has several entries. If this number was below the margin of victory, it will be insignificant. The start of an election process is the voter register. It must be a very clean document. In this case, they started the race with a register by their own audit as at the 16th of June. The register that was gazetted on the 20th of June, that register had 481,711 persons who were not supposed to be there. Duplicates, several entries. The margin of victory by which William Ruto passes 50% plus 1 is less than 70,000 within this margin. The margin of victory by which is declared more than Raila Odinga, 200,000, again less than this. So the universe of the elections was already compromised ab initio, and the number by which it is compromised could affect and did affect the results. To use my Supreme Court example, I will say, if all the judges were biometrically registered, we know there are 7 judges, but we go a biometrics audit, we find there are 9 voters in that register. Would we say that that register is authentic? If they were to vote on an issue, and then the return is 4-3, and yet the register had 9 people, would we say that only those who are legitimately qualified to vote participated? I will say not. In page 36 of my volume 1, the audit report finds that 638,814 entries were noted to be null IDs. You have registered voters on the register who don't have ID numbers. Null. That is the quality of your election document. And at page 37, the auditors find that there are generic users who cannot be attached to anyone, generic users of the biometric voter register system who cannot be attributed to anyone. But more importantly, the auditors found that there were 14 non-returning officers, users, accounts that had been granted access, voter access privileges on the identity data management system. Non-users, some of them are referred to as Embakasi South clerks. People who had access to the system and they were able to make changes on the persons who are supposed to be on the register. Non-authorized users, their own document. At page 39, audit report finds that there are users who are not gazetted returning officers that have access to the database. It is important that we note this. Page 42, IEBC's response to the audit queries. They said it was not humanly possible within the time available to deduplicate the register. That is, to remove those erroneous entries. So they are confirming they went into an election in which the register was compromised, and the number by which it is compromised could and did affect the results. They also purport to say that they cleaned the unauthorized users. At the time when they're doing it, your system has been compromised. There's nothing left to say. You are now running on autopilot, as the KPMG audit report says. The horse has bolted. The stable is broken. My lords and my ladies, it is my submission that when you look at the systemic issues arising and affecting the integrity of this election, should we even pay attention to the numbers which we are now being fronted? If the system was compromised from the beginning, the universe of the elections had been compromised from the beginning, that whatever numbers will come out of that universe of the elections, the voter register, does not matter. And I do believe even the third respondent, if he was the one filing this petition, will raise the same issues that I'm raising today. What should we do in terms of my reliefs? I urge my lords and my ladies, the problems of IEBC, and specifically the second respondent, are systemic, as I've said. The court should consider the conduct of this second respondent, Wafula Chebukati, and Professor Gulie and Mr. Molu. The common constant, they were the only commissioners who were in the 2017 general elections. They are the only commissioners who procured the elections technology. And they are the only commissioners again today who are dissenting. They are the minority commissioners who are trying to countermand a decision of the commission. Appropriate sanctions need to arise. In light of the disobedience of the court orders in Maina Kiai, the court was very emphatic on what is the role of IEBC and what is the role of the chairperson. Very clear. When he unilaterally ignores that court order, I urge this court to take that into account when making appropriate sanctions. When the same person in 2017, again, refused to accede to the orders of this honorable court in Petition 1 of 2017, this court should take that into account. We can't be coming back to you every election with the same problem involving the same person. It is time that Mr. Chebukati is shown that the will of the people of Kenya is supreme, and he must work within the constitution and decisions by these courts. That's why we are calling for criminal sanctions and appropriate reports to the DPP. Why should the people suffer constant anxiety around elections that are being bungled when the courts have sounded themselves hoarse and loud on what is your role, what are you supposed to do, what technology to deploy, how to protect that technology, and he's not doing it? If you look at, we've attached the PSC report, Public Accounts Committee reports, again, finds an indictment of the same person sitting in meetings where he's conflicted. Look at the KPMG report. The auditors are saying they are being given even the information requested so late in the day, on the 16th of June, for a register to be gazetted on the 20th of June. This was deliberate attempt to make sure that the election is compromised. Section 6 of the Elections Act required the register to be opened for inspection 90 days before the date, the notice of a general election. The notice came out on the 20th of January. The register ought to have been opened 90 days before the 20th of January for inspection. He didn't do it. He gave the auditors the report so late. But they still pointed out that your register has a problem, and he took no remedial action. He proceeded to conduct the elections in the way that he desired. What he ended up doing is what my grandmother, Sophia Magambo, calls Nairobi Karafu, Pata Potea. Nairobi Karafu to me, at the National Tallying Center, it is and I've had it on our affidavit, the national chairperson of the commission called both Raila Odinga and William Ruto. The whole day, nobody knew who the winner was. Even the commissioners didn't know the results because tallying had stopped. I refer to the affidavit of the 11th respondents. They have confirmed, even them, they were concerned. Why has the open display stopped? Why are you not announcing the results per constituency as you were doing before? That is what I'm saying my grandmother calls Nairobi Karafu. And my niece Mimi calls Piki Piki Ponki Pakamielo Disco. Because he called both of them. He called both of them. And he was the only person who knew who the disco would land on. It could have been either of them. It could have been William Ruto, it could have been Raila Odinga. It fell on William Ruto and he says, voila, you are the president. Is that how we intend to choose our national executive? We've reduced it to Mimi's childhood game of Piki Piki Ponki Pakamielo Disco.
Counsel again.
Yes, my lord.
I did give you brotherly advice. Be careful. That language appears to be alien to this court.
I'll be guided, my lord, I'll be guided. But the main point, so that we don't lose the crux of the point, is that the lack of transparency in the tallying and verification of the results, contrary to Article 10 of our Constitution, completely eroded public confidence in our Constitution. It completely left a very core exercise of a sovereign donation by the people to the whims of an individual not subject to any control. And that, my lords and ladies, should not miss the attention of this court. My lords, in our submissions, we've spoken about the DCI report and the penetration of the system. Again, just to buttress the role of this chairperson. My lord, the DCI, as has been submitted, is set up as a government agency to investigate crime. They did find that indeed there were foreigners who had access to what we call critical election instruments. And their forensic report has established the presence of those persons. In other words, in layman's language, the DCI report has corroborated what the KPMG report has found and authorized users and access to critical elections technology. Should we ignore that and say, just look at the numbers, forget about the process? I humbly submit that we cannot now even focus on the numbers. We should not even, because the process through which those numbers are being arrived at has been compromised. So that anybody inviting you even to look at the number is inviting you down an alley, a process in which the wish of the people has been convoluted. My learned senior John Mohammed, representing a poor voter, did say that voter just wants to see, just wants to know, how was my vote converted into account and the result of the elections. If the infrastructure and the process set up for that poor voter does not guarantee integrity, then, my lords and my ladies, it is my humble submission that the number that an individual ultimately comes out with at the end does not matter. If that number comes out in a manner that infringes the Constitution, you've come up with your number in a manner that violates specific provisions of the Constitution, then that number does not matter. The Constitution has to be upheld. Because the Constitution is what established the framework through which we will start generating that number. You ignore the Constitution, then it doesn't matter. We've not organized ourselves as a sovereign on how to arrive at the number. My lords, as I move to conclude, I think it is very important that I buttress this point on the meaning of Article 138.3c, because I see I still have 4 more minutes and I will not wish to donate them at the moment, and Article 138.10. The IEBC shall tally and verify the count and declare the result. That's the first step. And I've invited the Honorable Court, there are numerous decisions from these courts on what a result is, outcome. So the first declaration to take ownership of the elections is done by the IEBC once they've verified and tallied the count. And some of the tools of verification, number one are the KIMS kits. Because the KIMS kits were meant to send you voter turnout per polling station. So part of how you verify, you ask yourself, this particular polling station, as per the KIMS kits, how many voters logged in? Thank you. How many voters logged in and voted in that polling station? Once you establish that, you check on the Form 34As, how many registered voters are entered to have voted in that station. If the numbers are different, then you ask for Form 32A, assuming some were identified manually. Those are the steps of verification. But if the numbers in your KIMS kits are less than the numbers of the votes returned and are not supported by any Forms 32As, then that's a polling station to be flagged. It means the verification has not returned or cleared that polling station. That is what the IEBC does. Verification is not, as they're trying to attempt to tell us, is about looking at the UV mark, looking at the serial number. Those are just part of verification. But the verification, number one, is to identify that indeed the true universe came out and voted. And that is very important. Once the commission satisfies itself, we go to Article 138.10, in which Article 138.10, the chairman now walks out of the commission meeting together with all his commissioners, if necessary, and proceeds to now declare the result. Because remember what I said, the first declaration was done by the IEBC when they concluded their verification and tallying. Then the other declaration, 138.10, is done by the chairperson. And then he issues the certificate as an individual. So that to assume that the chairperson on his own can conduct, or that the staff of the commission are the ones to do the tallying and verification, that is erroneous. It is the commission that does it. The staff of the commission are spread everywhere. They report to the commissioners who constitute the commission. And the commissioners take control of that process. And finally, my lords and my ladies, it is not the first time we are holding elections in this country. To say that Mr. Chebukati didn't know what the law was. He knew. These provisions have been applied in 2013. They were applied in 2017, 1, and 2017, 2. And the commission functioned as a commission to conduct those elections. Why should we now move away? My lords, finally, in this election, we submit the people had their say, but the machines, technology, had its way. Please correct it. Thank you very much.
Petition number 4 of 2022, David Kariuki Ngari.
My lady, this is petitioner number 5 in the consolidated petition. My name is Metuga. I will deal with issue number 6 as framed by the court. My colleague, Mr. Njiru Ndewa, will deal with issue number 8. The petition is dated 22nd of August 2022. We have filed submissions dated 25th of August.
Counsel, let us confirm. Who is your client?
My client is David Kariuki
Ngari.
Yes.
Then according to our records, it's number 4, petition number 4.
I do apologize, my lord. It would appear I printed some ruling that reflected him as petitioner number 5
okay. Maybe
in the
after
consolidated petition.
After the consolidation, yes.
Yes.
The party is the same, no problem.
Very well, my lady. We have filed petitioner submissions dated 25th of August 2022. The supplementary submissions dated 28th of August 2022.
Sorry, you said that you'll address issue number?
I will address issue number 6.
And Mr.
Ndewa will address issue number 8.
Correct, thank you.
My lord, we have filed submissions dated 25th of August 2022. We have supplemented submissions dated 28th of August 2022. My lord, there is a quote attributed to the American statesman Harry Truman that the president, whoever he is, has to decide. He cannot pass the buck to anybody. No one else can do the deciding for him. This is his job. And my lord, it is my submission that constitutional mandates given to IEBC have to be performed by IEBC because the buck stops with the commission. Our constitution has been characterized as a transformative charter. Well, the only way it can be a transformative charter is if we breathe life to it instead of paying lip service. The principles that run through the Constitution, including transparency, accountability, participation of the people, have to be given. We have to breathe life to those provisions if the Constitution has to live up to its characterization as a transformative charter. It can also live to its characterization as such if the independent institutions under the Constitution discharge their mandates according to what is provided there. One of the institutions is IEBC. Under Chapter 15 of the Constitution, it has a critical function which is captured under Article 249A. It must protect the sovereignty of the people. And one of the ways it protects the sovereignty of the people is to ensure that the will of the people in electing their representatives reflects what the people have voted it to be. This is because, my lord, sovereignty is exercised directly. It can also be exercised by the representatives they elect. So by sticking to the principles that guide the process of election, that's how it can give the sovereignty of the people the life it deserves. Under Article 1, under Article 81 and Article 86, the electoral process has to observe, among other principles, transparency. It also has to be an accountable process. My Lords, the Commission is constituted under Article 88, and the national legislation that provides for the Commission is the Independent Electoral and Boundary Commission, that is Act number 9 of 2011. Under Section 5, a commission is established, and under Section 11 and 11A, it's categorical that the Secretariat works under the Commission. So the staff of the Commission performs a delegated function. The buck stops with the Commission. My plain reading of Article 138(3)(c) is that the process of tallying, verification, and declaration of the result is the mandate of the Commission. It's not the mandate of the staff or the Secretariat. This is also reiterated under Section 39(1)(c), paragraph B, which also states categorically that the function of tallying and verification is supposed to be done by the Commission. Was it done by the Commission? That is the only question, my Lord, I will answer. I will answer it through the eyes of the averments made by the 9th respondent, that is Professor Abdi Gulier, and the 4th respondent, that's in the consolidated petition, that's Honorable the Chairman Chebukati. This is how, from their own affidavit, without even going to the regulations in which they set out on how the verification was supposed to be done, from their own affidavits. When the other 4 commissioners are clear that they were not involved in the verification and tallying and declaration of the result, this is what they say in their respective affidavits. The affidavit of Professor Gulier, the 9th respondent, sworn on 20th of August 2022 in respect of petition 005, at paragraph 8, he is clear that once assigned a responsibility by the Commission, whatever recommendations he makes have to go back to the Commission for consideration. So from his own averment, it was clear that even when the Commission delegates a function to a commissioner, he has to report back to the Commission for approval. At paragraph 32 of his affidavit, this is how he described how verification was done and the result generated. That the Chief Executive Officer / the Commission Secretary came with the final result. That is on 15th of August 2022, when the commissioners were seated in a meeting. He acknowledges that the verification is not being done by the Commission. It is the Chief Executive Officer getting to the commissioners a result, a clear admission that they were not involved in the tallying and the verification of the result. Now, in respect of the 27 constituencies which have been mentioned, and there was doubt whether verification was done, this is how he puts it in paragraph 27, paragraph 35 of his affidavit, that these constituencies were verified in the presence of agents of candidates and included in the final tally. There's nowhere in that statement he says that verification was done by the Commission. Now, on why he did not even announce the result for transparency, then he says there was no calmness in the auditorium for them to announce the results. But then the question is, when it was restored, the chairman of the Electoral Commission was able to read the result in Form 34C. The question is, during that period, how is it that they could not read the result for the 27 constituencies? The chairman of the commission, Honorable Chebukati, in his replying affidavit to the fourth petitioner's petition, the affidavit is undated, but it was filed on 27th of August 2022. This is how he characterizes the verification of the result by the commission. At paragraph 31, he avers under oath that the verification and tallying was undertaken by a staff of IEBC with some commissioners assigned the role. My Lord, from the chairman's own averment, the verification is being done by a commissioner assigned the role, and the staff of IEBC. There is no indication anywhere that that outcome of the verification was brought before the commissioners before an announcement was made. It is understandable that tallying and a verification of over 40,000 polling stations is an Herculean task, and it cannot be done by 7 commissioners. But, my lords, if they delegate that function to the staff of IEBC and a commissioner or 2 commissioners, it is my submission that whatever report that comes out of that tallying and verification has to be placed before the commissioners before a declaration is made. My Lord, that was not done. Now, an explanation is given by the chairman of the commission at paragraph 25 of his affidavit in reply to the fourth petitioner's petition, when the fourth petitioner avers that no announcement was made for 27 other constituencies for purposes of transparency, this is what he responds: there was no legal obligation to do that. My Lord, there is no explanation given why it was done in respect of 261 other constituencies and not the 27 constituencies. It's my submission that in respect of those other 27 constituencies, there was lack of transparency and accountability. The chairman avers in that paragraph 25 of his affidavit further that Professor Gulie was prevented from reading the results, but there is no explanation further why he could not read the result for the 27 constituencies after calm was restored. And if at all tallying was already done for the 27 constituencies and a report prepared, my lords, this should have been included in the reply of the chairman to the petition to confirm that indeed the tallying and the verification had already been done. It's my final submission that the result that was declared by the chairman of the commission did not reflect the will of Kenyans, and it should not be let to stand. My colleague will take over the issue number 8. Thank you, my Lord.
My ladies, my lords, permit me to, my name is Dego Njiru, permit me to address issue number 8 in respect to our petition. And while addressing that issue, my ladies, my lords, I'll be seeking to answer the question whether or not the election that was conducted on 9th of August was a constitutional election. While I do that, my ladies, my lords, permit me to refer you to various affidavits, and I begin by referring to paragraph 52, paragraph 53, and paragraph 54 of our petition. I'll also refer to paragraph 51 of the Vice Chair's replying affidavit, that's the 5th respondent. I'll also refer to paragraph 25 of the Chairman's Chebukati's replying affidavit. I'll finally look at paragraph 19 of the second respondent's, William Samoei Ruto's affidavit. Why are these paragraphs important to these proceedings, my ladies, my lords? And while addressing that question, I am going to refer to various provisions of the Constitution. I'll begin by referring to Article 88 of the Constitution. I'll seek reliance again on Article 89, Article 97, Article 138, Clause 2. I'll also seek reliance on Section 2 of the Election Act, and I'll also seek reliance on Section 83 of the Election Act. My ladies, my lords, if you look at the affidavits that I have mentioned, and most importantly, affidavit by the chairman of the commission, at paragraph 25, he defines and says that he conducted tallying of election results in 291 constituencies. Paragraph 19 of Honorable William Ruto's affidavit, again he says that elections were conducted in 291 constituencies. The fundamental questions, my ladies, my lords, is how many constituencies do we have in this republic? If you look at Article 138, Clause 2, the Constitution provides that elections shall take place in each and every constituency in this Kenya. And when you define constituency, my ladies, my lords, you look at the provision of Article 4 and Article 5. Article 5 of the Constitution, which defines the territory of the Republic of Kenya. Then you further look at Article 89, Clause 1. It says there shall be 290 constituencies in the Republic of Kenya. And that is where the law contemplates that elections shall take place. But what happened on 9th of August is that we have submissions and averments that elections took place in 291 constituencies. The fundamental questions, my ladies, my lord, is where did this extra constituency come from? And is this extra constituency a constitutional constituency defined by the armpits of Article 89? There may be arguments that this was a constituency by the diaspora. Yes, they may have their rights under Article 38 to vote. But the question is it a constituency within the meaning of the law? We submit that to the extent that individuals not confined to Article 89 of the Constitution, to the extent that the elections of an extra constituency not defined under Article 97 took place during that particular time, that contaminated the election. You must then ask yourself, to what extent was the contamination? Article 138, Clause 4 requires the Commission to compute whether or not the president-elect has attained 50 plus 1%. We are submitting that these elections that took place in alien constituencies contributed to the computation of 50 plus 1%. Then you might ask yourself, my ladies, my lords, what then is the test that I'm trying to apply? I am applying the test proposed by Section 83 of the Constitution of the Election Act. It provides that an election can be voided if that election did not comply with the Constitution or other written law. And this is a fundamental question, my ladies, my lords, because a constituency as defined by Article 289, Article 89, that must be within the territory of Kenya as defined by Article 5, then contemplates a situation whereby there is a question of representation. It subjects the people of Kenya to exercising their sovereignty through the representation of those people. The question then that begs an answer is, how can an election that has been infiltrated by alien constituencies be regarded as a constitutional election? We submit thus that waives the fundamental requirement where IBC under Article 88, Clause 5, is required to conduct an election within the armpits of the Constitution. It is a mandate within the IBC that the mandate is so fundamental that it cannot be waived, it cannot be fettered, it cannot even be relaxed. An individual cannot create a constituency. If it was in the interest of Kenyans, while promulgating this constitution and adopting this constitution and giving this constitution unto themselves to create an extra constituency, there was nothing that was as easy as saying as such. My ladies, my lords, permit me to address the question of the 27 constituencies. Again, it has been submitted by my learned friend that under paragraph 25 of the Chairman Chebukati's replying affidavit, he has glossed over that weighty issue. He does not consider that 27 constituencies, which makes about 10% of the Kenyan constituencies, which translates to about 1.9 elected voters, were not included in the final tally. And what does he do? He makes and he amends and carefully uses the words which to apply. In his replying affidavit, he technically avoids the use of the word declaration and he uses the word announcement. The word announcement is not akin, is not similar, and does not mean declaration. Why, my ladies, my lords? Because Article 138, Clause 4, presupposes a declaration of all the polling results by the IEBC. So this declaration is not akin to announcement. And therefore, my ladies, my lords, we are submitting that the chairman of the Electoral Commission was lost on what he needed to do. He is making a declaration and reducing the question of declaration to the question of a master of ceremony. The IBC chairman was not called upon to just officiate the process. He was called upon to execute a constitutional obligation. And therefore, when the law speaks about a declaration, there must be clear demonstration that the same was done. What happened, my ladies, my lords? He says that the law does not require him to do so. He does not annex any evidence that the same was declared. He does not annex any evidence in his affidavit that there was tallying. He does not aid this honorable court to make an opinion that yes, the requirements of the Constitution were met. Finally, my ladies, my lords, we need to interrogate the conduct of the chairman of the IBC. We need to interrogate the previous and even the current conduct of the chairman. He was effectively described by my senior line friend, Mr. Norji, that is a person who has perfected the art of imperfection. And he has perfected the art of imperfection by making sure that he conducts a lone ranger process. Remember, my ladies, my lords, to the run-up of the second election in 2017, a similar issue arose, which necessitated the resignation of the commissioners. How long shall we allow an individual to keep on transgressing the law? how long shall we allow this individual to keep on putting Kenyans and to subject Kenyans into uncertainty? The law requires that there must be certainty. And the certainty contemplated by the law is that I shall cast my vote and my vote shall count. And why are the 27 constituencies fundamental and key to these proceedings? If you look at our paragraph 57, 52, 53, and 54, we have listed those constituencies. It is where an individual or the first petitioner has his supporters. It is where he has his support base. So were they left out as a matter of design? Were they left out by default? Or was he holding someone's brief? My ladies, my lords, we submit that to the extent that those constituencies were not tallied, were not verified, and the declarations were not made, then this election did not meet the provisions of the Constitution. Finally, my ladies, my lords, he says in paragraph 25 that he can announce elections anytime that he so wishes, even if there are some constituencies that have not generated their results. But what does section 39 subsection 2 of the Election Act provides? It provides, my ladies, my lords, I would wish to read this. The chairman may declare a candidate elected as president before all constituencies have transmitted their results. The operating word here, my ladies, my lords, is the word before. So if before, at the time he's declaring those elections, the constituencies have not generated their results, he can declare. But the situation where we are in, my ladies, my lords, on 9th, going by the dictates of Maina Kiai's case, the chairman had received all the results from the polling stations. It was therefore incumbent upon him to make sure that they are included, to make sure that they are tallied, to make sure that they are verified. Finally, my ladies, my lords, permit me to delve on an issue that was dealt with in the morning by my senior learned friend, Mr. Governor Orengo. My ladies, my lords, I am referring to the replying affidavit filed by Honorable William Ruto, and I'm referring to page 111, where it indicates a preliminary statement of the IGAD election observation mission to the August elections. And that paragraph, my ladies, my lords, these were individuals who are observers of the elections, who are out there observing the elections. When it came to the question of analyzing the voters' turnout, the report says, it is annexed in its affidavit, that in most of the polling stations visited, voters' turnout was noticeably low and recorded around 55%. Those were observers out there in the field observing the elections, giving a return of the 55%. And this 55%, and you can see how this computation of the turnout is fluid. It is so fluid, it's a lever. You are not able to hold it. The chairman is not able to tell about the voter turnout. The report is giving us a different voter turnout. So what exactly was the voter turnout? So that the voter turnout then can assist us in the computation of the sum of 50 plus 1%. Finally, my ladies, my lords, there's a question as to the computation of the 50 plus 1%. That when the chairman gave his final public address about the voters' turnout, he deliberately exempted those individuals who voted manually. To date, we are not aware of how many people passed through the manual registration. How many people voted manually? I mean, my ladies, my lords, it is not within the armpit or within the purview or within the power or the discretion of the chairman of the Electoral Commission to do that what he wishes. He cannot deal with the question of elections from his aspirations or from his wishes. He must deal with the question of election as dictated by the Constitution, as dictated by the election laws. Finally, my ladies, my lords, we urge you to admit our petition and you dismiss the replies filed by all the respondents and find that this election was not conducted in accordance to the Constitution. And my ladies, my lords, that you give an order that the sovereignty of the people must be respected. And the sovereignty of the people cannot be respected, cannot be upheld where there is serious transgression at the wishes of the chairman of the Electoral Commission. Finally, my ladies, my lords, there needs to be a retribution. There needs to be a stop of all these transgressions. How many times shall we subject Kenyans to these processes? How many times should we appear before you with the same grievance every day, after every elections? There ought to be a stop. And a stop is making sure that the proper sanctions, criminal sanctions, as prescribed by the Election Act, are meted against any transgressor. And there is no one who is above the law, including the chairman, so that people may learn to respect the law. I'm so obliged. I donate the 26 minutes to the court.
Thank you very much.
Seconds.
Those are seconds. Thank you very much, Council. As regards petition number 7, we have Mr. Omtata appearing for himself, and Professor is appearing for the other. So I think you'll share the time, Prof.
Yes, thank you, Your Ladyship. Well, our submissions will be in two parts. The first part will be qualitative, and I will address myself to the law and complement the submissions that have been made by learned friend, Senior Counsel James Orengo, learned friend, Senior Counsel Philip Murgor and Feroz Noroji, on the questions of compliance with the law and on the unconstitutional nature and the non-compliant nature that the first respondent, Mr. Chebukati, employed in running the presidential election of 9th August 2022. My lords, the person I do not want to be now is Professor Githu Muigai, because every single advocate in this court has spoken to the violations by his client. Violations, my lords, that border on the violation and speak to the violation of Article 3.2, the unconstitutional proceedings that led to the issuance of Gazette Notice 9773 of 2022, issued on 16th August 2022, that declared the president-elect. My lords, we shall be asking that that violation or that Gazette Notice be vacated as we make several orders, my lords, under Section 84 of the Elections Act and Article 143 of the Constitution. My lords and my ladies, let me start by submitting that my submission shall be around one, the issues framed by the court, particularly, my lords, issue number 8 on illegalities and irregularities that, if applied disjunctively as this court has ordained before, my lords, will lead to a compelling order of nullification of the elections of 9th of August 2022. But I will also, my lords, and in view of the powers of this court under Section 3 of the Supreme Court Act, delve into the interpretation of Article 143. And my lord, perhaps because this court is also the jurisprudential head of the judiciary, to see, my lords, whether there are possible sanctions or possible findings that this court can make other than the order of nullification. And my lord, that will be in my last submission. My lord, let me just touch on the second part. The second part that my learned friend Mr. Omtata will deal with will be the maths electromaths, the mathematics of the election, we will demonstrate by way of a PowerPoint presentation that none of the candidates met the 50% plus one vote as per the tallies that were read by Chairman Chebukati on the percentages weighed against the voter turnout and the votes cast, my lords. And that will show that if indeed no candidate attained the 50% plus one, then this court has a daunting task. One, of course, after the exercise that is ongoing, the exercise that is going on with the server, my lords, we will be asking this court, my lord, to think of the possibility of declaring a winner after the outcome of the access to the back end of the server. That's number one. But number two, my lords, patently, the results announced by the chairman of the IEBC were unconstitutional because they did not emerge from the commission. And granted, my lord, that they were unconstitutional, if the court then is unable to arrive at a result as to who won the election, my lord, then of necessity the court would then would have no option but to proceed to nullify or find that it was conducted illegally. My lord, let me just proceed because of time to the key submissions. My lord, it is patent and glaring that there was non-compliance with Article 81A and D of the Constitution, read together with Article 86E of the Constitution. The elections were not verifiable in as much as voting took place. The process of tallying of the presidential vote from the polling station and the issuance of Forms 34As transmitted to the constituency tallying center and finally to the national tallying center, my lords, was not a verifiable process. My learned friend Philip Murgor has spoken largely to the access that two individuals had to the system. He had spoken of one Dahir and one Kwanusu who had access over 1,000 times Mr. Kwanusu, the PA to the chairman, Mr. Professor Githu's client. Clearly, my lords,
I would like to request the Honorable Court that we conduct this petition in the tradition, in the very long honored tradition of each counsel arguing his case without any sideshow.
My lord, it is a fact that the chairman is Professor Githu's client, but I will, because of the discomfort, address myself to the
Yes, I'm speaking.
Yes, my lord.
I think you should treat your colleagues with respect. We all know that who is representing who. So make your point.
My lords, I will proceed. I will proceed. I will not mention Prof's name going forth. But my lords, the violation is glaring in view, my lord, of the fact that the non-verifiability of the process from the tallying center as held by the Court of Appeal, my lord, we've spoken to this severally, to the National Tallying Center of what each presidential candidate received, my lord, is a subject of an unconstitutional act. My lord, that is point number one. My lord, therefore, the counting, there was a violation of the duty to count each vote cast by an individual as contained in the Form 34A transmitted to the National Tallying Center and as uploaded to the Form 34Bs and 34C that was used to declare the result in Form 34D, my lords. My lords, granted further, that violation is also reflected, my lord, in the violation of the Elections Act itself. Because, my Lord, there was a requirement that once the tallying is done and the verification done under Article 138(3)(c, it was not the chairman but the commission that was required to undertake that process. And my Lord, I want to speak to the affidavit of the chairman himself. Other advocates have submitted on the self-importance that the chairman presumed in conducting the final tally, ignoring the mandatory nature of Article 138(3)(c. This court has dealt with the question of interpretation of statutes and of the Constitution, my Lord, where there's a compelling word, shall. Article 138(3)(c is compelling in nature. It does not give the chairman an option of consultation or of assuming the role of the commission. It states, my Lord, that the commission shall undertake the process, not the chairman. The same term, my Lord, is used in the second schedule to the IBC Act and in sections 4 and 8 of the Elections Act. My Lord, if I may just read 138(3)(c. It provides, my Lord, that the process of tallying, my Lord, after counting the votes in the polling station, the independent electoral and our commission shall tally. My Lord, where shall is used before a verb, citing my learned friend, senior counsel, it leads to an inevitable and compelling option. And this is what the courts have interpreted in several cases that we have handed over to the court, my Lord. The cases in Kirain Investments and National Land Commission, this was the finding of the court, again citing the findings of the Court of Appeal on the same question. Wesley, Judge of Appeal, laying down the consequence of the use of the word shall as peremptory. So, my Lord, that of itself, any action reflected in the affidavit of Wafula Chebukati that denotes any action by himself in assigning other members work, my Lord, and in eventually purporting to act under 138(10) alone without consultation invalidates the entire result that he purported to announce and invalidates the issuance of Form 34C and D, in which he purported to announce the results of the election. My Lord, ipso facto, the duty to transmit, tally, and collate was therefore violated. The regulations, my Lord, 39(1)(c) of the Elections Act required two tallies, the physical tally and the electronic tally that ought to have been transmitted. Non-compliance, my Lord, is evidenced in the affidavit filed by Cherere and by the 4 commissioners, my Lord, and an admission by the chairman himself that the tally was not compliant with section 39(1)(d) of the Elections Act. My Lord, going forth, the complementary nature of compliance reflected from sections 39 to section 44 uppercase A of the Elections Act, my Lord, denotes non-compliance by the commission, but also an admission, my Lord, that there was no commission the moment the commission was divided and was working in different forms. My Lord, Article 3(2) of the Constitution provides that there shall be no government established other than through the Constitution. So that any violation that leads to an unlawful process, my Lord, cannot stand. And this court has the duty under Section 3 and Article 140 to invalidate an offensive action that is unconstitutional. My Lords, we submit that through the affidavits that admit the interference with the transmission system, the interference with verification, and the duty to declare the presidential election by the Commission, the result gazetted in Gazette Notice issued by the chairman, being Gazette Notice 9773 of 2022, was unconstitutional and cannot stand and must be invalidated by this court. My Lord, in view of time, we wish to submit that even aside finding that even the duty of the Commission as created and enshrined, my Lords, in Article 249, is governed and dictated by the principles under Article 10, my Lords. And my Lords, where public officers do not act in a manner donated by Article 10, then their actions must be vitiated by the court. And this is the forum where such actions must be vitiated. My Lords, the law is clear. The maxim ex turpi causa non action, which has been developed over the years, my Lord, by Lord Mansfield, initially in Holtzman versus Johnson, later in Tinsley and Milligan, and now in Patel versus Mizra, speak to the fact that no circumstance can allow this action to stand. The opposing affidavits, my Lord, the opposing affidavits filed by the 4 commissioners and the 3 that speak to the violation of paragraphs 5 and 7 of Schedule 2 can only lead this court compellably, my Lord, to find that this is a matter that this court must handle in the manner that lex arbitri would dictate. My Lord, the principle ex equo et bono used by international tribunals to settle questions. In the local framework, my Lord, we refer to Solomonic wisdom in 1 Kings 14. The court should look at the opposing affidavits. The court should look at the misconduct of the chairman of the commission. The court will then compellably apply the dictates of fairness in this matter and find that the people of Kenya were violated by the conduct of an election outside the framework of the Constitution, through the violation of the process, through the violation of the outcome. And my Lord, we want to demonstrate to the court, before I wind up, that mathematically, and this is where the law meets mathematics, no candidate attained the 50%. If the chairman read the results that he read and the percentages that he read out of the registered voters that cast their votes, my Lord. My Lords, the maxim amiable compositeur that I shall look at after my learned friend Mr. Omtata presents the results, my Lord, will show you that this court has no option but to nullify this election. There's no option. There's no option. Mr. Omtata.
Gather because you're all senators, you're learning friends now?
Yes, my Lord, Mr. Omtata is a serial litigator and a public interest, a public defender in this country. And I respect him for that role, my Lord.
And now a senator? And now he's a senator?
Yeah, he's a senator for Kisii County. He replaced the Attorney General, who did not run for office.
Members of the Honorable Court, in my submissions, I will rely on the petition we filed jointly with the three others. It's dated 22nd of August. I also have submissions which I filed alone, which are dated 26th of August. And I also have a further affidavit which is dated the 29th of August. My lords, before I remark on the mathematics, I just wanted to make a small observation as regards point number 1. And I think the elephant in the room is point number 1. What kind of election does the Constitution of Kenya anticipate? That's a question that I've seen documents and videos by some members of the court telling me that even this court does not comprehend the kind of election anticipated under Article 81 and 86 of the Constitution. Short of a digital election, you cannot meet the constitutional threshold.
Mr. Mutata, what
Yes.
did you say?
I said I've come across publications and video recordings by some members of the bench who complain that the 14 days the court is given to determine a dispute concerning the presidential election is too short. And I'm saying that statement demonstrates the failure of, with due respect, the honorable judges of this court to understand the electoral architecture in the Constitution of Kenya 2010. The Constitution of Kenya 2010 only anticipates a digital election. And if we are dealing with a digital election, 14 days is too much. But if you are dealing with a paper election, a manual election, you need maybe 2 months. That's where I wanted to begin. And this election does not meet the threshold in the Constitution at all. The presidential election that I'm referring to, that's before this court. It's not simple. That's why you have got spoiled ballots. In a digital election, you don't have spoiled ballots or rejected ballots. And you don't even have the question of whether the spoiled or rejected ballots count. It's not verifiable. Right now, I cannot verify where the ballots I cast went. I don't know. The moment I dropped them in that box, I lost all contact with those ballots. There's no mechanism of verifying. A digital election would give me a serial number by which I could track my ballots. So I'm saying that if you look at the threshold in the Constitution, we must work towards a digital election and move away from these paper elections, which allow human interference without sometimes leaving footprints. I would now go to my submissions. I was supposed to be given some aid. Yes. Where the...
If the time could stop running, we had supplied the electronic instruments to the court.
Assistant. You beg the assistant.
I don't understand what you said. I come there. Oh, open for me the PowerPoint document. Go to the next slide. Yes, we're looking at an analysis of paragraph 26 of affidavit filed by Mr. Sunkuli in petition number 7, paragraph 226. And you can see that he's giving us, he gives data of how the KIMS kits transmitted on 9th August at 17 hours at the close of polls. He gives that figure. On 9th August at 20:45 hours, about some 3 hours and 45 minutes, he gives his figure of 13 million. Then, most surprisingly, you have two entries. It is the entry that which gives us at 14 hours and 14:40 hours. The KIMS kits are transmitting some 23 hours later, still transmitting data. And we're saying that that data is not acceptable. So we come to the next slide. I'll just run through given the short time I have. When you got that slide, you look, they tell you at 20:45 hours, on 9th August 2022, some 13,731,215 people voted. Polling turnout recorded on 10th August is 14,239,862 ballots. And on the 10th, that is the day after the voting, and we know that it's only elders where elections were taking place. Now, when you analyze that data, you find that 508,647 ballots are added on the 10th. And you saw Land Council Willis show that the audit of the register had almost the same number of ghost voters. So you can see from that data that they present, Mr. Sunguli presents, you are able to isolate 508,647 ghost cast votes, which are more than the difference between the two leading candidates. If you go to the next slide, and if you look at the ballots that are recorded to have received, to have recorded on the next day, you are talking of some 1,665,412 curiously cast votes, which are coming out after the close of voting, and that's after 3 hours after the close of voting. So if we take the total tally now, you find that the tally is close to it's about 1.7 million votes. That spike in votes is not possible. That spike in votes is part of the problems we're having, that fellows were having access, the KIMS kits that were still transmitting data from locations that are not clear. Because the KIMS kits that were in polling stations
the voting stopped on 9th. And giving an allowance of 3 hours or 4 hours for people who are still on the queue, you would understand by why Akim's kit would still be transmitting 23 hours after the close of elections is something that is difficult to comprehend. Also, my members of the Honorable Court, if you look at the Form 34C that has been published and interrogate the data there, if you look at the total of the variables ascribed to each candidate, the amount that you get is 110 votes less than the number that has been printed on that paper. Now, if you look at, that thing was boggling my mind. Initially, I thought it was a simple error of addition. But it has come out it was not a question of 1 + 1 = 3. Because when you look at paragraph 32 of the replying affidavit of Mr. Sunkuli, yes, I'm on, yes, go to the next slide. Next. Yes, sorry, I forgot to, thank you for directing me. If you look at paragraph 32 of the replying affidavit of Mr. Sunkuli, the total voter turnout in the table when you subtract from it, as given in the table, the number of rejected votes on Form 34, you get exactly that figure of 14,213,137, which in that replying affidavit they claim was an error of addition. But if you interrogate the raw data, you find that that figure is the valid figure. So the votes attributed to the candidates are fictitious. From paragraph 32 of Mr. Sunkuli's replying affidavit. So, when you go on to the next slide, I've reproduced I've tried to factor in the figures that Mr. Sunkuli gives, and when you add them, you get the 14,213,137. Yet, when you add the figures attributed to the individual candidates on Form 34C, they come to 14,213,027. That is not an innocent mistake. It is a situation whereby somebody has left a trail that they were working backwards from a certain figure which they had, and they were working backwards, and so they would going to get that. And most important, I would also refer to the affidavit signed by the chairman, filed by the chairman in petition number 5. At paragraph 95 of his replying affidavit, shown on 26 August 2022, the chairman presents the exact figure of 14,213,137 as the total valid votes cast for all the 4 candidates. So if that is the figure that's coming from the raw data, that's the figure that's carried in the affidavit, then the values attributed to each one of the 4 candidates are fictitious and cannot count. And therefore, that Form 34C is an invalid document. Go to the next slide. Sorry, next. Yes, so in that slide I'm saying, we can only conclude that these figures, which form the contents of Form 34C, are cooked. You cannot have both of them in the same document. And this court should not allow that document to stand at all. And the conflicting figures, and those conflicting figures for valid votes cast of 14,213,137, and the other one is the one when you add the values of the individual candidates, the 4 candidates, you get 14,213,027, is evidence that the results were worked backwards to achieve a desired or predetermined outcome. Therefore, the declared percentages for the 4 candidates, no, the votes attributed to the 4 candidates and the declared and the percentages attributed to them is all fiction. Now, I got to address the question of whether you can achieve, if assuming that what in the totality of the announcements made by the chairman, any of the candidates realized 50% plus 1 vote.
Just checking on the time.
Yes. There's no display for the time, unfortunately.
According to mine, time is over. If you could just finish your slides.
Okay, thank you.
Because they seem to have lost theirs.
Okay, so a further analysis of Form 34C on voter turnout, the chairman announced, and that issue has not been retracted at the close of voting. He was answering a particular question, and a journalist asked him, as matters stand now, what is the national voter turnout? And he said, oh, that one, I can deal with it. And he said, as at the time he was announcing, it was 65.4%. And according to what the Kim's kids had reported. And he expected that value to go up when all the Kim's kids had reported and the manual had been included in it. So when you calculate that against the total voter register, the national voter register of 22,120,458 votes, you get that the voter turnout as at that time was 14,466,799 votes. The next slide. So from Form 34, the tallies are ascribed in Form 34. You get, when you factor in the rejected votes, you get a total value of 14 million.
I will never engage or even consider participating in such kind of
gets 48.372118662. The next page, Wahiga would get 31,987, which would translate to 0.222856771%. Wajakoya at 61,969 becomes 0.431,74497. And so now there are these other votes, the 140,000 votes, 140,138 votes. Since those votes were not, we don't know how the voters gave them to the candidates. We cannot randomly allocate them to any candidates. So they become the fifth variable here. Those ones amount to 0.976356086%. In the scenario, no candidate acquires 50% plus one vote that is required under Article 138.4, 138 Clause 4, Paragraph A. And so, with those few remarks, I pray that the Honorable Court allows the petition and the other petitions, and then...
My Lord, I had intended to make the prayers in lieu of the jurisprudential weight of the mundane questions that I would want this court to
Sorry, Senior Counsel. Can Mr. Omutata confirm? I'm trying to go through the record. This PowerPoint presentation you just made, is it part of your pleadings?
Yeah, it is part of my pleadings in a law.
Word for word?
Yes, word for word. In fact, I've just got in for purpose of my hearing.
Okay, thank you. Unless you are changing, that is not word for word.
No.
So if it's word for word, we don't need any other copy.
But of the most important is the father affidavit. Because when I did the first one, I did the petition, I did not have the information that came from... I did not have the information that came from Mr. Sunguli's affidavit. So I would request the court to pay particular attention to the father affidavit. That's why I had the benefit to compute the figures with the figures that the commission supplied. That's all my
Thank you.
Compelling are the figures that finally mathematics finds its way into invalidating.
So, General, you have no leave to address the court after time. Why don't you start from there?
Just to make prayers.
From where? From what time?
Leave from the bench.
Start from there.
Your Lordship, may I seek leave? Just make prayers.
Senior Counsel, we agreed on the ground rules yesterday. Your time is up. In fact, his time went over because he was on the PowerPoint. We noted he went over by 6 minutes. So please, yes, if you have anything, you can reply when you have time to reply. Rejoinder.
It's okay, Your Lordship, I appreciate it.
I will now invite counsel in petition number 6, Njuria Yokabichege and others.
May it please, Madam Chief Justice, Deputy Chief Justice, and other members of the court. My name is Kibe Mongai, appearing with Ms. Wairi Mukeru for Julia Nyokafishege and 3 others. First of all, let me say that I'm very happy to be responding last, and particularly to have had that very good presentation by my long-term friend, Mr. Okiya Omutata. My Lord and my ladies,
The petition before the court has been introduced. The petition is dated 22nd of August this year. It is supported by two affidavits, an affidavit sworn on 22nd of August by Julia Shege, and a further affidavit that she swore on 28th of August 2022. We have done submissions which were filed on the 30th of August 2022. That is when they were stamped. And we have also done a bundle of authorities as required. Now, having introduced the pleadings that we have filed, I wish to, looks like I don't have the petition, but basically the petition before the court, the petitioners are basically arguing for invalidation on the simple ground that there are so many violations of the constitutions and the electoral law by IEBC and its chairman, as the case may be, and as a result of which, those violations constitute such severe illegalities and irregularities that the results announced ought to be nullified. We have pointed out, for purposes of the specific issues raised by the court, we want to dwell with issues number 6 to 9 that were identified by the court. And to sum up, because before we go to the exact issues, is we shall basically be talking about 3 violations before we refer to the conclusion. Now, the first issue is the fact that over 700,000 people who ought to have voted during the general election held on 9th of August were deprived of the opportunity to do so. Number 2, we shall be arguing that the third respondent, that is the Commission, contravened or violated its duty of accountability, transparency, and public participation during the 4 stages that we shall shortly be outlining, and in a manner that it declared the results of the presidential election. The third issue that we shall be referring to is the fact that the third and fourth respondents violated the procedure set out in Article 138 of the Constitution in discharging their mandate of tallying and verifying the vote at the Bomas of Kenya. I start with issue number 1. The constitutional basis for issue number 1 is Article 38 and 138A of the Constitution. And in this, we are referring to the number of people, 700,000 by our count, who ought to have voted and were deprived of the opportunity to vote. Now, what is a complaint? The complaint, members of the court, is laid out at paragraphs 56 to 60 of the petition, paragraphs 56 to 60 of the Constitution. And the supporting evidence is laid out in paragraphs 24 to 28 of the supporting affidavit sworn on 22nd of August 2022. The long and short of those paragraphs is that the petitioners are basically saying that by virtue of Article 1 of the Constitution, the people's sovereignty is exercised in Kenya by 2 major methods: through voting, and collectively we only exercise that right during a presidential elections. And number 2, by voting in a referendum. Now, under Article 38, it is expected that the right to vote for a candidate of your choice is recognized. The same way under Article 138(3)(a) of the Constitution, voting at a place appointed by the IEBC by all persons eligible to vote. Now, on that basis, Regulation 90 of the Elections General Regulations Act, General Regulations 2012, were done under the Elections Act. Regulations 90 provides, is a short provision that I need to read, that the Commission may make provisions for the voting by election officials, observers, patients admitted in hospital, older members of the societies, members of the defense and security forces on duty, prisoners and nomadic pastoralists, and other persons who by reasons of any special need, including disability, are unable to access a polling station. 2, the Commission may from time to time publish notices on the manner and procedure of the conduct of special voting, and such notices shall be read as part of these regulations. So the long and short of it, but I want to tie up with the facts, in paragraphs 50, the petitioner say no such notices were issued with regard to the persons in contentions in this particular contest. Who are those persons? Those persons include at least 500,000 elections officials. They include at least 180,000 members of the security forces. It includes those people who are in hospitals and others who may not be in hospital. But they are placed in such circumstances that special arrangements ought to have been done to ensure that they were able to exercise their rights under Article 1 and Article 38 of the Constitution. Now, why have we chosen the figure 700? The figure 700, as you will see from the affidavit, has been chosen for the simple reason that there should be no contentions about it. These figures, these are elections officials. The IBC chairman is quoted in the newspaper report that is attached to that affidavit, in fact confirming that indeed all this number of peoples will be engaged during the election day. Their engagement during the elections day follows up of necessity and in the nature of their duty that starts at earlier than 6 a.m. and ends long past the counting period, that those are the people envisaged under Regulation 90, that special arrangements to ensure that they vote would be made. It is not denied, in the face of how these complaints being made, that those arrangements, in fact, were not made by the Commission. Now, it is important to point out these regulations were made in the year 2012. Of course, it is interesting to know, faced by these complaints, how did Chebukati answer them? He answered them in his affidavit by first of all saying prisoners were allowed to vote under Regulations 90. He says diaspora Kenyans were allowed to vote under Regulation 90. And he also says very old people and sick people would be first on queue, and so such instructions were issued to ensure that those kind of people would vote first with a little bit more convenience than others. But Your Lordships, it is important to note that when it comes, for example, that prisoners voted, prisoners have been voting in Kenya in the presidential elections, not so much because IEBC has been complying with the law, but because I believe it was Judge Lenaola, when he was at the High Court, made an order first that prisoners to vote in the presidential elections, and number 2 in the referendum. And that was done. Even the reasons why diaspora voters vote in Kenya is again because of another subsequent court decision. So that where we stand today, for purposes of Regulation 90, IEBC cannot give a single instance that in support of ensuring that as many Kenyans as possible will vote for the presidents of Kenya and exercise their rights to franchise has ever done anything. There is no evidence of that. Now, during the preparation of this petition and afterwards, for purposes of these kinds of violations, the right to franchise, it is a very serious thing across the world. Because as many of us are entitled, and that is why even this right was given to prisoners, to ensure that we vote. You find in very many other countries where elections have been nullified because of the issue of franchise. But you do not have a single instance, at least to the best of my knowledge, that this has ever happened in Kenya. And this could probably explain why, even after the Constitution is clear on this issue, that facilitations be made to ensure as many people as possible and those in special circumstances, those arrangements have never been done by IEBC. It is my submissions that given the results that were declared on the 15th of August this year, voting by up to 700,000 voters, even if that was adjusted, how many of them could have been registered and how many of them could actually have voted to the actual averages, you would still have arrived at a very big figure of more than 300,000 that directly and on account of non-compliance with an express provision of the law were unable to vote. Did the failure to make that accommodation, those arrangements to ensure those people voted affect the results of the elections? Undeniably. If those people had voted, it is our submissions that the results of the elections could have been affected. And my Lord, it's in my submissions that unless and until this honorable court take up that issue as a serious issue of violations of constitutional law, then Regulation 90 could as well be an empty piece of legislation. And therefore, part of the enforcement of ensuring that the universality, that the free franchise and universality of it is respected would be to ensure that a very serious elections was violated on its account. And it is on that reason that when we read our submissions, we are urging the court to do exactly that. Issue number 2 has got everything to do with the fact that the duty of accountability and verification, as we had said, was violated at various stages. It is my submissions that there are at least 4 stages in which this happened. Number 1, stage 1 ordinarily occurs the stage between 20th, the election period. A gazette notice was issued on 20th of January to signify the commencement of the election period. That period ended on the 8th of August. Then there is stage 2, voting day. Then there is stage 3, which is a 7 days period under the procedure set out under Article 138 of the Constitution. Stage 4, in my submission for purposes of a presidential election, it is the 21 days period under Article 40 of the Constitutions that you are dealing with right now. Now, what are the stages at stage 1? The issues at stage 1, and I will link them up with how they tie to the elections, is the fact that in this particular case, IEBC, according to my clients, was supposed to ensure that they set up a technology system that was transparent enough to ensure that the outcome would have credibility in the eyes of the electorate. The one single issue that we have pointed out for purposes of that in an elections where you've said you have recognized voters using KIMS-KIT, it has been recorded, it is our submissions, that on day 1, in their affidavit they say 6 hours, that at least 6 hours after the conclusions of voting, Kenyans ought to have known what many people voted electronically and using any other complementary system of voting. And my lords, it is my submission that the failure to do that, one cannot be able to speak of a technology that worked if the most important component that a voter ought to know, the right of a voter to know, yes, we voted. If we reach this number, this man is president. If we reach this number, this one is president, or is in the opposition. That number ought to have been given without any dispute. There should be no controversy about it. Yet the fact that you have all these controversies about the register just points out to the issue that on that critical element, there was serious failure of that technology. But it may not necessarily have to be a serious failure of the technology, in the sense that it could well be that the manner in which now you conclude voting, Forms 34A were uploaded, but the actual figures were being named on day 2. This is day 2 after the arrival of all Forms 34A. It is our submissions and my hypothesis that any person, and nowadays there are so many books that you can read anywhere and you can buy anywhere, that says how do you rig elections. If one was set out to rig an election such as this one, then one of the most important variable would be the voters register. And in this case, it is our submission that the fact that on day 1, 6 hours after the election, we were not told in a controversial manner, and after Kenyans have invested in a technology, that this number of people voted, this opened the system in the subsequent verification process to the kind of abuse that more other able people in that area have spoken about today. But that, on the face of it, appears to be where the opportunity arose. I go to the issue still at stage 1, the issues of the nomination. We have said in our affidavit that for purposes of Article 99 of the Constitution, the presidential candidates were supposed to be subjected to qualifications under Article 99. The manner in which that was done for purposes of presidential election, the second respondent was actually not subjected to it, and at the end of the day, persons with unresolved questions under Chapter 6 is today Deputy-elect of the Republic of Kenya, arising out of the failure of IEBC to enforce the law. The next issue is the publication of a Gazette Notice number 9540 on 8th of August. This Gazette Notice in our submissions was an instrument of illegality. My learned colleague, Mr. Nyambodi, says that IBC chairman is always inclined to produce Gazette notices even when none is required. I read it differently. If you read Gazette Notice as an instruction manual, it makes a lot of sense. In this sense, that in the ordinary scheme of things, and particularly when I was working in the human rights movement, when you deal with a lot of police officers and other people on those junior ranks, this activity will be carried this way. They will not tell you the Penal Code says this, the Police Act says this. They will tell you the forces standing order, which they are socialized to understand, says this. So this was the forces standing orders. So that for purposes of the day when this verification was being carried out under this, what we are calling stage 2, it was being, and it was published on the eve of the election. There was also the bad faith that on the eve of the elections, you publish such kind of a Gazette notice that runs directly counter to the Constitution. Why would anybody do that in good faith? There was lack of good faith. Because in the Republic of Kenya, during my practice of a couple of years in public law, we are aware this is the kind of stuff that we present in Constitutional Division and the Judicial Review Court to confirm whether or not it complies with the constitutions or statute. Therefore, when you publish such a Gazette notice, an instruction manual that would be deployed during the verification exercise, and the following day is a public holiday, you cannot be taken to have been done that with the best of intentions. We go to stage 2, voting day. Voting day, the first violations as we talked about, not everybody entitled to vote under Article 138 in the presidential elections actually voted on account of non-compliance with the law by the IEBC. The second issue for purposes of that day, I've already talked about it, is a voters register. That on the elections day, and we have said 6 hours, you needed to know how many of us voted. The moment that information was not provided, the system and the process was exposed to anything could happen. And actually by the 15th of August, the worst, and all that could go wrong actually went wrong on the 15th of August. And therefore this is why we are saying these violations were not just minor violations. They were violations that indeed went into the heart of what is before this court, the disputed elections. At stage 3 is what we call the procedure under Article 138. Well, my constitutional law mentor, Dr. Gibson Kamau always used to tell me, and I believe most of the people who had the privilege to be his pupils, that the Constitution must be understood in a historical context. And therefore it is important that we understand Article 138 in a historical context. What is this context? This context, my lords, is this, that we do not have an equivalent of Article 138. We do 6 elections. The Constitution has not told you this is a procedure at the parliamentary elections or the governor or anybody else. It is only reserved for one position, the president position. The procedure are the presidential elections. And this was to leave no room of doubt that this is how in which the verification process ought to be carried about. My lords, the process after we vote in a presidential elections, I first voted in 1992. And since that year, the first multi-party elections, after voting, of course in Kenya they tell you, vote, go home, watch it on television. You will get to know the outcome. How it has always worked is that you are there at home, results are read from constituencies, from everywhere else across the country. It is a ritual that happens every year as far as I can remember since the year 1992. Now, what is the importance of this ritual? It is important to remember that in the year 2007, this ritual was disrupted by the events that happened at KICC. The disruptions of this ritual led to the post-elections violence, and the rest of it we are all aware what happened after that. So that it is not a simple ritual. And so that in the year 2010, when the Constitution was written, it provided for a sections and 7 days and a procedure, setting out in no uncertain terms, this is how after people vote for their president, we are going to process the issues. So that the Constitution having dealt with that issue against that historical background, you cannot have a situation where subversion through a gazette notice is tried to be effected. That would be treason in every sense of the word. I go to the issue of what's the importance of the ritual. To the winner of an election, this ritual that we saw in this constituency, what you got in my neighborhood is very important. Because the people, while we are seeing all this being displayed, and remember that during Bomas, the display to show Kenyans that these are the results that were coming in, this is how the figures were adding up, that was disabled at some stage. So that what effectively this meant, that the true purpose of Article 138 ends up being defeated. Defeated in the sense that for the winner goes and declares that I had the most numbers in accordance to Chebukati. And the loser, everybody else says, I do not know how you got those numbers. I actually thought I had more than you had. This is what was tried to be prevented. But it is equally important, the procedure under Article 138 for the loser. Why is it important for the loser? Because the loser, and in this case the loser is a loser with say about 6.9 million votes, quite a number of Kenyans. This is a loser on his 5th time seeking the presidency. The last one he says he lost under controversial circumstances. There was everything necessary to ensure that for purposes of these elections, if you are to lose the election, the math must make sense. It must add up. The Kenyans, those people who voted for you, must also see that you did not do very well, because it is clear these people in that other place did not vote for you as you expected. Now, but when you have now a true situation on the 15th, the dramatic events of the 15th of August, where even 27th constituency, my clients are there waiting at home. I was also equally waiting at home. Those results are not announced. Then how do the people who are supposed to be losers understand that they genuinely lost in the elections? That would strip the process of legitimacy. But it is equally important for another reason that Wallace Oinka talks about in one of his essays. And I believe the essay is published in a book called Climate of Fear. And Wallace Oinka, in an essay titled The Quest for Human Dignity, says that in war, it is important that those who lose a war should not be stripped of their dignity. And basically what this means is this, that even after losing war, you are not stripped naked, in the sense that you are told you lost half of your country, but you must be left with the other half. That is if you are in the Russia-Ukrainian kind of situation. That is a whole idea that nobody should lose absolutely. And when the Constitution talks about fairness, about transparency, it is to enable that this is processed in a manner that everybody else would be able to understand and to process the victory or to process the loss, if it turns out that it was a loss. Now we go to the issue number 4. I wish I could say more. I'm just trying to watch myself. Stage number 4, the final issue is the Supreme Court issue. We served Chebukati with our affidavit. And I would not say he's arrogant, because that may not be a permitted language. But the language that he used is one that shows lack of remorse. You will read the affidavit. On the issue of, why didn't you make arrangements for everybody to vote? We were talking about specific people, election officials. Then he says, oh, prisoners voted, diaspora's people voted, and all these other people voted. Now, that was not the issue. I think they are needed, and this is accountability to the Supreme Court. And that is the design of the Constitution. That now that a violation has been committed, what do you have to tell the court about it? You could not even say it was an oversight. The next one I will recommend to the next chair to ensure it is done. There was no such thing. Then we go to the next issue. In our affidavit, the third petitioner says, I was disturbed about the events of 15th, because in the morning of 15th at around 7:30 a.m., I was shown some text that seemed to show the results that now are being announced later. Why was it disturbed? Because at that time, votes were still being counted. People are being told in constituency A, this is what people got. How does Chebukati react to that? Oh, everybody with a good calculator could have downloaded these forms 34A and calculated. Now, Kenya is a country with extremely low digital literacy. To say, and when such a thing that would cause concern, that there was a problem, and you say this information was readily available, leaves a lot to be desired on the part of a public officer. I start with finishing with the issue of legitimacy. It is important that winners should have legitimacy. And it is also important that the losers also should be treated with dignity. When we read the affidavit of Honorable William Ruto, he says, oh, so many people, why are you pretending that you are acting for all Kenyans? So many people agree with my victory. But it is also equally true, so many other Kenyans don't agree with it. And therefore, in a constitutional democracy, as I conclude, it is absolutely important that when you win, and Article 38 says you win it this way, it must be confirmed. Thank you very much, Chief Justice.